Syahira binti Mama Azmi. My metric number is 25 DPM 20F 2017.
Hi, my name is Aziatul Azhar binti Khairuddin. My metric number is 25 DPM 20F 2007.
My name is Humaira Maisara binti Osman with metric number is 25 DPM 20F 2027.
Hi and Assalamualaikum. My name is Nura Ashiki binti Nok Zahar. My metric number is 25 DPM 20F 2013.
Hi, my name is Siti Nurul Nabila binti Rasul. My metric number is 25 DPM 20F 2001.
Assalamualaikum and hi to Madam Nur Jahatudini binti Muhammad Nazari. Today we would like to present the task given, which is end of chapter. This time the task is divided into two situations. Situation 1 asks us to advise Fakrul and Ramzi on their legal position by relating the issue to the Contract Act 1950. But before we start, I would like to introduce myself. My name is Humaira Maisara binti Osman with metric number is 25 DPM 20F 2027. Alright, for situation 1, the issue is whether the issue is Ramzi is an agent to Fakrul. Then, whether there is a contract of agency between Fakrul and Ramzi. Situation 1 referring section. First, ratification. When a person is not an agent but acted as if he has the authority to act as an agent. In the event of the authority, we may elect to ratify or to disown the act. 2. Duties of agent to principal. First, obey principal's instruction under section 164. An agent is bound to conduct the business of his principal according to the direction given by the principal. 2. Act according to the customer prevail if there is no instruction from the principal. Under section 164, an agent is bound to conduct the business of his principal according to the direction given by principal, or in the absence of any such direction, according to the customer which prevails in doing business of the same kind at the place where the agent conduct the business. So, that's all from my part. Next, I will give to Nur Ashikin to present the next content.
Thank you to Humaira Maisara. Next is application. The reason why I chose section 149 Contract Act 1950 is because it is shown when Ramzi purchased a bookcase and 3 storage shelf from Abu for 500 ringgit without Fakrul consent. As we saw in the question, we know that Fakrul warned Ramzi that he should not buy anything for the shop, but Ramzi ignored the warning. Next is section 164. It is shown when Ramzi sold the wardrobe with 65% from the price display and a bedside cabinet for 60% from the marked price. He ignored Fakrul's instruction to take at least 70% of the price displayed. Next is the conclusion. The first conclusion is Ramzi is an agent to Fakrul. The second conclusion is when Ramzi sold the wardrobe and the bedside cabinet with the lower price from what Fakrul has said and also purchased a bookcase and 3 storage shelves, Fakrul didn't complain and accepted the purchase, which means Fakrul has ratified the act of Ramzi. So there is a contract of agency between Fakrul and Ramzi by ratification. Next, I will give the slide to Aziatul Azhar.
Situation 2. First is issue. Whether Mr. Freddy buys coconut oil from the same factory he makes olive oil. Based on the agreement, they have discussed to get coconut oil which has a melting point of 78 degrees Unfortunately, when the processing was complete, Mr. Freddy had tested the coconut oil and his desired condition were not met as it had a melting point of 68 degrees and was easily melt if used. Next is section. The case can be linked to the description section 50, where coconut oil does not meet the cool melting point. The melting point they promised to make it was 78 degrees, and even though the process was complete, Mr. Freddy realized that the melting point of coconut oil was only 68 degrees and the oil had melted. The factories did not meet the required condition and they did not even tell Mr. Freddy about it. In this case, Mr. Freddy can sue the factory as well as cancel the contract and ask for a refund of his money.
Based on our research application, the application that have on this case, section 15, is Mr. Freddy was having an oil supply that the same sample which there is an implied the condition that the goods should correspond with the description in what the factory given. But in other way, Mr. Freddy were having a problem with that factory because the sample that given a promise will not correspond with the description sample.
For related case, the same as situation 2 is Samsung Hong Kong Limited versus Kim Time Trading Limited in 1999, 2 HKC 447. This case about the seller contracted to sell 1.5D polyester fibers to the buyer. However, the polyester delivered were 1.4D. In this action, the plaintiff claims against the defendant damage for a breach of a sale contract. The writ was issued on 5 December 1995 and on 4 June 1996, interlocutory judgment for liability was entered against the defendant with damages to be assessed. So, the court held this case because of it was clearly a sale by description, where the buyer was legally entitled to reject the delivery and terminate the contract on account of the delivery of goods which did not meet the contract description. As the term implied by Section 15 is a condition, the failure of a seller to supply goods that conform exactly to the contract description amounts to a total failure to perform the contract as a whole and not merely a breach of a term in the contract. The consumer who selects a good being exposed for sale or hire is not prevented from rejecting the goods by reason that it was not supplied by description. So, the conclusion is that Mr. Freddy buys coconut oil from the same factory he makes olive oil. Based on the agreement, they have discussed the coconut oil which has a melting point of 78 degrees. Unfortunately, when the processing was complete, Mr. Freddy had tested the coconut oil and his desired conditions were not met as it had a melting point of 68 degrees and was easily melted if used. Based on the issue, this case can be linked to Section 15, which is the description, where coconut oil does not meet the cool melting point. The melting point they promised to make it was 78 degrees, and even though the process was complete, Mr. Freddy realized that the melting point of coconut oil was only 68 degrees and the oil had melted. The factories did not meet the required condition and they did not even tell Mr. Freddy about it. In this case, Mr. Freddy can sue the factory as well as cancel the contract and ask for a refund of his money.
So, what we advise to Mr. Freddy is, Mr. Freddy was required to monitor the plant while it was processing coconut oil based on the comments made. This can be avoided due to their previous negligence so that Mr. Freddy obtains a satisfactory item and it is not a loss. Mr. Freddy should be cautious when promising and should make a contract or agreement between the two parties so that in the event of a mistake, Mr. Freddy can recover the damage he has already suffered. Once promised, the plant must be bear the risk of its own negligence and reimburse Mr. Freddy's money, or Mr. Freddy will sue the company.